Instagram. Hi, everybody. Hope you are having a wonderful Monday evening. I wasn't here last week. Honestly, what happened was I was compiling the stories and I literally had two stories, and I was like, the show's going to be over in 10 minutes. Hey, Kels Butter. But I'm back this week. I've got a full roster. I'm really excited to talk with you guys. Hi, the Gab Society. Um, if you are new and you don't know what's happening, don't worry. I'm going to update you very, very shortly. Just relax. Those of you who are OGs, grab a drink, grab a snack, grab something to record some notes. We're going to get started officially at 8:05. Just want to give people a few minutes to get into the room. How's everybody been? We haven't talked for a while. Let me know what's going on with you guys. Any good news? Any accomplishments? Also, Instagram. Please let me know if you can hear me properly because I have my phone adjusted in a particular way and I want to make sure that it's not blocking the mic. So if you can hear me, just give me a thumbs up, okay? Um, Clubhouse, you guys are good. Facebook and YouTube are doing their thing. Me and my big old bun that won't, it's like so big, it's getting out of frame. But yeah, we are going to get started at 8:05. I have some great stories. Thank you, the Gap Society. I have great stories for you guys. Hermes has won their metaverse lawsuit. Savannah James is not playing with y'all out here. Um, you know how they say, what is it? Actually, no, we'll leave that for later. Um, Someone is trying to trademark a hashtag. And what else are we talking about tonight? And also, Virgin Air just came into a super amount of money. Okay. So we're going to talk about all of this and more. Thank you guys for the thumbs ups, letting me know that you can hear me. We're going to talk about all this and more. We're getting started at 8:05. For those of you who are new, just to give you a brief description, this is a show where I teach business and legal concepts using pop culture and celebrity news. If you want the full rundown, just hold on a couple more minutes and I got you, okay? What else? But yeah, let me know, how are you guys doing on this Monday? Any fun plans, guys? I'm going away in 9 days. I was very lucky on my last trip to Jamaica to make some really awesome friends, and they invited me back to stay, at their resort, and it's gonna be great. But yeah, so so we're getting started in less than a minute. Um, like I said, grab a drink, grab a snack, grab something to record some notes, because there's always something that new that we learned with these stories, okay? Um, all right. So just a few more seconds. If you've got kids, don't worry, they can sit in on this too, okay? A lot of these kids, they have $1 million businesses and they need to know. All right. I had somebody contact me today, and she wants to gift her nephew a session with me to start his business. So I'm really excited to see younger and younger people getting into business. Okay. All right. So dang, this is like the longest 60 seconds ever. Come on, 8:05. But yeah. Okay, here we go. Let's get started. All right. Hey, get you a grip. Welcome, welcome, welcome. Happy Monday, everyone. Welcome to NPL Legal Dish. This is my Monday broadcast where I teach business and legal concepts using pop culture and celebrity news. If this is your first time seeing my face or hearing my voice and you're like, who's this lady on the internet and why should I listen to her? I'm Natalie Pierre-Lewis. I'm the host of the show, and I'm the owner and operator of NPL Consulting LLC, a business formation firm. What that means is I help people like yourself get your business paperwork together. So things like making sure you have your articles of incorporation, getting your EIN numbers and DUNS numbers so you can pay taxes and pay your employees, having contracts ready for clients and partners so you don't get left holding the bag and everybody knows what's expected of them, protecting your intellectual property through trademarks and copyrights, and preventing you from getting sued for discrimination by teaching you proper hiring and training strategies, okay? I help you do all of this and more. If you're wondering why I'm qualified to help you do all of this, I'm very happy that you asked. I'm a licensed attorney. I have been one for 16 years and counting. I have started multiple businesses for myself and others, both online and offline. I've had many careers in the realms of entrepreneurship, the law, education, hospitality, and administrative support. And most important, I am very passionate about making business and legal education as accessible to everyone as possible. Not everybody has the time, the money, or the desire to go to business school or to law school, but a lot of you have amazing business ideas. And if you're going to be successful, there are just some things that you need to know. There's no way around it, okay? So that is why I am here. And yeah. So if you are in the startup phase of your business and you're looking for some legal guidance, you're like, I don't know where to find these forms. I don't know how much this costs. What kind of licensing do I need? These are all of the things that I help you with. So book a one-on-one session with me. Go to linktr.ee/NPL Consulting Firm, linktr.ee/NPL Consulting Firm, linktr.ee/NPL Consulting Firm. That is the only link in my bio on Clubhouse, on Instagram. It's all over Facebook and YouTube. Linktree/NPLconsultingfirm.com is also where you can download my free biz launch cheat sheet that will help you choose and start your dream business in 7 days or less. Linktree/NPL Consulting Firm is also where you can find many of my digital products. I do a lot of ebooks and video trainings and things like that. So go to linktree/NPL Consulting Firm. It's where you can find anything and everything having to do with NPL consulting. Okay. So now that I have talked about what I do, let's talk about this show and how it works for those of you who might be new. So I pull stories from the news, stories from blog sites, stories that you guys send to me in my DMs, and I pull the ones that have lessons that we can learn as business owners, and we talk about them. So this is a time for you to get involved. It's a time for you to ask questions. It's a time for you to give comments. Okay, and hold on. Give comments. Yes, give your comments, but keep it clean because my mother watches and I'm not explaining why people are cussing. What else? Yeah. So we're gonna have a time. I want you guys to get involved. I am gonna ask you questions. So keep your fingers on the buttons, all right? Okay, so let's get started with our first story of the evening. Now, how many of y'all have heard of the metaverse? If you have, give me like a computer emoji. Give me 2 computer emojis if you have been to the metaverse, like you have one of them headset things and you've like experimented with the metaverse, okay? While you guys do that, I'm going to tell you this story. So this is a case that's been happening for a very long time. Hermes sued a creator who was making Meta Birkins. Now, if you don't know, Hermes, the company, they do make the famous Birkin bag that all the celebrities have that people are, breaking their necks to get. And when the metaverse, thank you, get you a grip. When the metaverse kind of, was introduced to the masses, someone took it upon themselves to make Meta Birkins, NFTs. So they were basically selling, hi, Miss Jovemore. They were basically selling virtual Birkins, right? You couldn't touch them. Hold on. I have a thank you, Joella. Okay. So you couldn't touch the Birkins, these Meta Birkins, but you could purchase them, right? And supposedly each one was unique and it was like an NFT. I'm still not hip to the NFT thing, but whatever. Anyway, so the creator of the Meta Birkins, he was on the metaverse, selling his virtual Birkins, and Hermes was like, No, hello, we make Birkins. You can't do that. So the creator said, well, your trademarks have nothing to do with with virtual products. Your products are physical. You make physical handbags, right? So of course Hermes, they were not taking that lying down. They took it to court, and they have been fighting this battle, I want to say, for at least a year. And there is finally a conclusion. Now, what do you guys think happened? Do you guys think that the court sided with Hermes, or the court sided with the Meta Birkin people? So do you think the court said, Hermes, you're good both in the physical and the virtual world? Or did they say, you know, virtual and physical are two different things? What do you guys think that the court said before I tell you what happens, or what happened, I should say? Excuse me. What do you guys think happened? I'm gonna give you like 10 more seconds. I really hate dead air, so I hate leaving. Get You a Grip said two different sections. Kels Butter said different things. Actually, no. The court sided with Hermes. The court said to the people making Meta Birkins, look, your entire product is based on the reputation of these physical handbags. And since then, Hermes has filed trademarks within for virtual goods. But Hermes has won $133,000 in damages from the Meta Birkin company because the court is like, look, these things, they are very, your product is based on this physical product. So the court has agreed with Hermes. They have granted them or awarded them $133,000 in damages. Now I'm sure the Meta Birkin people are probably going to appeal. If there are any updates on that, I'll let you know. But what do you guys think about that ruling? Do you think it was right? Do you think they got it right, or do you think they got it wrong? Hi, Mr. Too Rare. Do you think they got it right, or do you think they got it wrong? What do you think? Like, I think I got it right. I think they got it right because it just doesn't make, it's kind of like the almost like the Russia thing. So a lot of companies pulled out of Russia. They took their brands, and Russia said, well, we don't respect your trademarks anymore. So you've got all these people in Russia going to trademark things that are already existing, like McDonald's and Starbucks. And I feel like this Meta Birkin thing is kind of the virtual version of that. I'm great. But yeah, let me know what you think about that, okay? Next story that we are talking about. How many LeBron James fans do we have in here? If you are a LeBron James fan, please give me a basketball emoji. Okay? If you're a LeBron James fan. Now, if you're a LeBron James fan, or even if you aren't a LeBron James fan and you just are a casual observer of basketball, you know that LeBron James is considered one of the best, if not the best, player in the NBA. And he makes a pretty penny, right? But he's always out on the road, and somebody got to take care of home. Thank you, Mr. Too Rare. So at home, we have. Can anybody tell me the name of LeBron James's wife? Can somebody tell me the name of LeBron James's wife? Okay. On and off the court, great person. Awesome. Now, while you guys let me know if you know who LeBron James's wife is, LeBron's nickname is King James, right? And with every king, there has to be a queen. So I call, thank you, the Gap Society. Yes, Savannah James. So today's title is in reference to Savannah James, LeBron James' wife. Now, I like Savannah. I was reading a story the other day, because their son Bronny, he's like about to be signed into the NBA, and the drafting people, the scouts, they're complaining because basically Savannah, she got all the fences up. She's like, you're not getting to my son before you go through me. And I like that. She's protecting you. She's protecting the family, all that, right? But Savannah doesn't just take care of the family. Savannah has her own ventures as well. And recently, Savannah James filed a trademark for a lifestyle brand where she would sell athletic gear, coffee, yoga, things like that, right? And the name that she trademarked, or she filed the trademark application for, was Balance, BLNCE. So the word balance without the A's, BLNCE. The trademark that Savannah James filed is called Balance, BLNCE. Okay, now again, like I said, she's filed it to sell things like athletic clothing, coffee, yoga, lifestyle brand things, right? Here is the problem. There is a brand out there that is opposing this trademark application. Can anybody guess what brand might be opposing Queen James's application for Balance with no A's? Give me a quick guess. Can you guess who might have a problem with Savannah James trying to trademark the word balance, albeit with a unique spelling, for athletic clothing, coffee, and yoga? The Gap Society said Nike. No, not Nike. It has to do with the name. Savannah is trying to name her line Balance. I'm going to give you one more try. I'm gonna give you one more try. Yes, Joella got it. Sorry, the Gap Society. Joella got it. New Balance. Absolutely. You're perfectly right, Joella. So New Balance has filed an opposition to Savannah James's trademark application for the word balance, BLNCE. They're like, look, we are New Balance. We have been in the game. We have longevity, and there is a high probability of confusion if you guys allow Savannah James to be able to trademark this word balance for her the products that she's selling. Okay, so now we know New Balance, they make athletic gear, they make sneakers. Do they make clothes? Oh, no, the Gap Society. Those are two different companies. Does New Balance make clothes? I don't know. I know they make sneakers, but do they make clothes? Y'all let me know. But basically, New Balance is like, look, if you guys let Savannah James have BLNCE, they make it all. Okay, people are going to confuse that with New Balance, or they're going to think that we are in business together, which we are not. So New Balance is opposing Savannah James's application for the name Balance for her line of products. What do you guys think about that? Do you think that New Balance is just protecting the brand, or are they doing too much? Is New Balance doing the right thing by opposing this trademark application, or are they doing too much? Because as a trademark owner, you must zealously protect your brand, but you also want to make sure that you don't go into the realm of trademark bullying, where you kind of use your money to shut down anybody that you don't like, right? So what do you guys think? Do you think that New Balance has a credible argument that there could be confusion, or do you think that they are just doing too much right now? Joella said yes, their website shows they make hoodies and athletic wear. Okay. Mr. Too Rare said they don't own the word balance, though. I feel like that's pretty strict. Okay, so we've got two things here. Fuzzy Fozzie said, oh no, Joella said shows they make hoodies and athletic wear. Fuzzy Fozzie said they sell sportswear, okay? Savannah wants to get into selling athletic gear, which I'm assuming means sportswear, hoodies, sweatshirts, right? Things like that. Now, on the other hand, Mr. Too Rare said they don't own the word balance, though. I feel that's pretty strict. You're very correct. They do not own the word balance. But you also can't have two similar names within the same kind of category. My favorite example, you can have Dove soap and Dove chocolate, but you can never have two Dove soaps, and you could never have two Dove chocolates, right? Now, albeit these are two kind of different names. You have New Balance and then Balance spelled in a unique way. But I think there is an argument there for a potential for confusion. Now, you don't have to agree with me, but let me know. Let me know what your opinions are. Mr. Too Rare said, "I feel like they know the potential the James family has, and near future it will be a problem for New Balance with them having the word balance in it." I totally. Yes, they could overshadow New Balance, because you got LeBron, Bronny's on his way up, and okay, yeah, that's a really good argument. So now, there has been, other than the opposition filing, there's been no movement. So we're going to have to wait and see what the USPTO says. But do you think that Savannah should be able to get this trademark? If you think Savannah should be able to get this trademark, give me a crown emoji, okay? If you think they should let Savannah have this balanced trademark, give me a crown emoji. If you do not think that they should let her have this trademark, give me a red balloon. So if you think Savannah should win, give me a crown. If you think Savannah should lose, give me a red balloon. Okay? What do you think? Hey, 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 hey. What y'all think? I'm gonna give y'all like 15 more seconds to get your emojis in. Joella gave me a red balloon, so you don't think Savannah should win. All right, Joella thinks that Savannah shouldn't get this. Mr. Too Rare gave me a crown. Okay, so we've got people on both sides of the fence here, and I think it will be interesting. Actually, I have two crowns now, so two people think Savannah should get it. One person thinks that she shouldn't. This will be an interesting thing to watch. So keep your eyes peeled on the news. Maybe do some Google searches here and there. You can even do a trademark search on the USPTO website. You can do a test trademark search to see if there have been any updates on that trademark, okay? And if I hear anything, I will definitely let you know, okay? Next story that we are talking about. Have any of you guys ever tried to go into business with your family? If you have ever tried to go into business, hi Snacks 410. If you've ever tried to go into business with your family, give me a heart emoji. Doesn't matter what color. Just give me a heart emoji if you have ever tried to go into business with your family. Okay? Now, we have plenty of examples of people who've gone into business as a family. Thank you, Get You a Grip. Sometimes it works. Thank you, Kel's Butter. Sometimes it doesn't. It's thank you, Mr. Too Rare. It's always, sad when a family can't work things out. But in the world of intellectual property, meaning trademarks, there is no such thing as, blood over everything. Mr. Too Rare said the hardest thing ever, right? Okay, so here's the thing. There's a restaurant out in Texas. It's called Hutchins Barbecue, okay? It was started by a father and his three sons. Dad's name is Toy. Another son's name is Wesley. There's a Tim, and there's like a Tony, okay? So Toy started the barbecue company with his three kids. Toy decided to retire, I guess, and I don't know what happened, but basically the article I read, the youngest son took over the business from his dad and his brother. So the youngest son is running Hutchins Barbecue, right? Dad, Toy, and the oldest brother, Wesley, they decide that they're going to open their own barbecue restaurant, and they call it the Original Roy Hutchins Barbecue. Okay? Now, the first restaurant they started, the one that the youngest son took over, is called Hutchins Barbecue. The one that the dad and the oldest son started after is called the Original Roy Hutchins Barbecue. Do you see a problem here? Do you see a problem with these two names? Do you see a problem with these two names? Do you see a problem with there being two restaurants, one named Hutchins Barbecue and one named the original Roy Hutchins Barbecue? Is there a possibility of confusion? Because that's the biggest thing about trademark infringement, right? Kels Butter said the name is the same. Right. And these are all relatives. This is father and son. Um no, it is a problem because Hutchins Barbecue is trademarked, right? So now Tim, the youngest who took over the original business, he has to go after his daddy and his older brother to protect the original trademark. When you have a trademark application, it doesn't matter who the other party is. You have to fight for it. As a matter of fact, LeBron James's son, Bronny, no, was it LeBron? Yes. I forget. It might have been. There's been a couple of sports players' children who have tried to trademark their name and haven't been able to because it's too close to their parents. Like Shaquille O'Neal's son was denied his trademark, or actually his father's company opposed his application. For the trademark. I think the same thing happened to Bronny when he tried to trademark his name as well. Kels Butter said that's dad. That's dumb on dad's part to do that. I guess. I don't know what's going on. I feel like there's a lot more behind this story. Like Mr. Too Rare said, I feel like it's some hurt feelings and whatever. Now, Tim, who took over the original business, he's like, you can love your family and hate their actions. He's like, I love my family, but I got to protect this trademark. So if we got to go to court, we're going to go to court. Okay? Mr. Too Rare said, it's loopholes to everything, though. One letter, one number, or symbol could change the entire trademark or business copyrights of Turkey. Right, but if they are in close proximity to each other, right? So if you have Hutchins Barbecue on on Street A, and then you have the original Roy Hutchins Barbecue 5 blocks away, there might be a possibility of confusion, right? So that's why Tim, the baby of the family, is going to have to sue his daddy and his older brother for trademark infringement, which is really sad. But yeah, when it comes to intellectual property, you cannot. Blood doesn't mean anything. Jimi Hendrix's brother was sued for trademark infringement by the company that controls Jimi Hendrix's trademark because he was using Jimi Hendrix's name without permission. So it doesn't matter who you are. It doesn't matter who you're related to. If you don't own the trademark, you can't use it. Okay? All right. Before we move on to our final few stories of the evening, I want to remind you guys that you are watching NPL Legal Dish. This is my Monday broadcast where I teach business and legal concepts using pop culture and celebrity news. If you are in the startup phase of your business and you're looking for some legal guidance, you don't know where to go get these forms, you don't know, what is the cost for me to get all this done. This is what I do. I help people take care of the legal paperwork side that they don't want to think about. That's my jam. So link up with me. Go to linktr.ee/nplconsultingfirm. That is the only link in my bio on Instagram, on Clubhouse. It's on Facebook. It's on YouTube. And you can book yourself a free 15-minute consultation if you are a first-time client. Okay. So now Mr. Too Rare said, "Oh yeah, that's real spiteful." Yeah, it is spiteful. Like something had to go down. I don't know what went down. How did the baby end up taking over the whole family business? And how come the daddy and the oldest son are starting there? Like something over there ain't right. But whatever. And that's another reason why when you go into business with your family, I always tell people this. If you're going into business with anybody, especially family, I don't care if it's your mom, if it's your pastor, if it is your child, your spouse, your twin sibling, you need your partnership contracts so that everything is on the table, so everybody knows what's expected of them. Okay? All right. Moving on to our next story of the evening. Okay? Now, it is not impossible to trademark a hashtag. However, you have to be really creative, right? One thing you don't want to happen is for what you're trying to trademark be generic. My favorite example of this is Baby from Cash Money. When they came out with the song Bling Bling, he didn't realize how big it was going to be. And he said, one of my biggest regrets is that I didn't trademark Bling Bling because people are now using it everywhere. And he was unable, hi that Brandon guy, to trademark it because it had become so common. It was generic at that point, right? So there is a law firm called Pound Law, okay? And before, social media and hashtags, they were using the hashtag sign law for their advertisements, and they had a vanity phone number. Now, by vanity phone number, when you were watching the TV as a kid and it'll be like a phone number that spells out the business name or something like that. They had a phone number like that. I don't know, like 1-888 law, whatever. Right? Now this only worked on cell phones. It didn't work on landlines, only on cell phones, okay? This hashtag law thing. Excuse me. So now that they've been using hashtag law since 2006. And again, remember they have like a jingle, they've got a phone number, whatever. Only recently, like within the last 2 or 3 years, this law firm, Pound Law, they are trying to trademark hashtag law. The pound sign, the hashtag sign, and law. Okay? Or at least they were trying to. Why do you think that might be a problem? To be trying to trademark hashtag law in 2022, 2023, the year of our Lord. Okay? You use hashtags on your rotary phone. Sir, you don't even know what a rotary phone is. Mr. Toure, if you're following me, don't worry. Okay? The information will be there. Just, hit that notification button. But what was I saying? Okay. So why do you think why do you think, or what do you think about the possibility of trademarking hashtag law? Do you see an issue with it? This company's been using it since 2006. They public use. It's generic at this point. If you go, I'm gonna do this right now. I'm gonna go to. Oh, I can't do it on here. Somebody. Ooh, you know what? Here, I could do it here. I'm gonna go on Instagram from my computer, and I'm gonna type in hashtag law and see what pops up, or how many things pop up. Hashtag law has 6,836,293 posts. Just that hashtag law has almost 7 million posts, right? So it's everywhere. It's too common now, right? Pound Law, if they were really serious about this, they should have trademarked this way back in 2006 before social media blew up, because 2006 was about the time that Twitter came out and we were really getting into hashtags. But yeah, so Pound Law, they tried to trademark hashtag law. The USPTO said, look, technology has evolved. Nobody's really using landlines anymore. And this hashtag, it's generic. So we're going to have to deny your application. Okay? So you got, hold on, I got names here. Joella said, very common. There are many companies and firms with law in it. Also, hashtag is very common. Joella said, ubiquitous. Right. It's everywhere. It's everywhere. So the USPTO said, no, girl. You waited almost 20 years too long. You should have done it in 2006 before Twitter, launched. And they can't use it anymore. Now, I don't know what they're going to do with this number, but I actually haven't heard of this law firm. But this is just a warning to you guys. If you are thinking about trademarking something, you want to do it early because you don't want to risk it becoming generic. Another famous or another popular example, Sheree Whitfield from Real Housewives of Atlanta. Her famous phrase, "Who gon' check me, boo," right? She never bothered to trademark it in time, and other people were selling merchandise with that phrase on it. It has become so generic that Sheree Whitfield cannot trademark her own phrase, okay? So you don't want that to happen to you. All right? Okay. And our last story of the evening, okay? If you have flown Virgin Air, give me a V. If you have flown Virgin Air, give me a V. And if you have flown Alaska Air, give me an ice cube emoji. If you have flown Virgin Air, give me a V. And if you have flown Alaska Airlines, give me an ice cube emoji. Okay, so that Brandon guy has flown Virgin Air. He's also flown Alaska. Okay, I've never flown Alaska Air. What else? Anybody else? Anybody else? Okay. Now, I have not flown either one of these airlines though, right? But Brandon, I don't know if you remember this, but a while we talked about this. We talked about this a while ago. So Virgin Air and Alaska Air had come into an agreement. Alaska Air was came into a licensing agreement with Virgin Air, and they were supposed to pay about $8 million a year to Virgin Air for the right to use the Virgin Air trademark. I think there was a merger happening. And part of the merger was they had to pay to use the name. Okay. Now, this contract, because this was a contract, it was a licensing agreement, was supposed to run through 2039. 1 year into the contract, Alaska Air decides, well, we don't want to use the name anymore. So they stop paying. Okay. Where do you see the problem here? Where do you see the problem? So the agreement was you pay us $8 million a year for the right to use the trademark. They used it for a year, and then they stopped. They didn't use it anymore, so they stopped paying. What's the problem? Does anybody see the problem? Do y'all see the problem? They went against the agreement. They owe more now. Very good, Mr. Too Rare. Look, just because your circumstance, that's why people make contracts, so that when circumstances change, you don't shortchange somebody else. Alaska Air said, well, we stopped using the name. And then the court said, girl, that wasn't the agreement. The agreement was that you were paying for the right to use the name, whether you used it or not, right? So it doesn't matter if you used it once or you used it a million times. Your agreement is that you will pay this company $8 million every year until the year 2039 for the right to use the name. Okay, not if you use the name. So Alaska Air lost that lawsuit or lost that legal battle, and Virgin Air has been awarded $160 million in damages by the court. Alaska Air should have just paid the money, because what's it, $8 million a year from, let's just say it started in 2021. I don't know. I don't do math well, but I feel like it would have been a lot cheaper for them had they just paid the $8 million. But this is just a reminder. When you sign a contract, you are saying that, barring some extraordinary catastrophic event, I'm going to follow through with this. You can't just not follow through on a contract because you changed your mind. That's the whole reason why we have contracts. All right. Now, this is very important for you guys who are creatives, because if somebody makes a big order from you and you don't have a contract, if they're like, well, I don't want it no more, you don't have no paper to enforce it. So make sure you have your contracts ironclad. That's something I can help you with. Okay. Mr. Too Rare said, damn, I'm smart, I can't wait to get some contracts. Yes, please do. That Brandon guy said 20 years. That's 20 years worth of payments times 8 is 240 million. Actually, they might have came out better. They might have, because they have people who weigh out the risks of certain moves. Alaska Air may have said, we might have to take this to court, but it might cost us less. So had they okay. Oh, so they made them pay the 20 years worth. Okay. All right. I see it. All right. Either way, when you have a contract, it is your duty, your legal duty, to honor it to the best of your ability, barring something that's out of your control. Okay. So that is the word that I want to leave you with after that story. Okay. So those were the stories that I wanted to share with you guys tonight. You guys have been an amazing audience. Thank you for the participation. Thank you for the commentary, the questions, the emojis. I really appreciate it. If you feel so inclined, please share this broadcast with your friends who are interested in business. I really have a passion for educating entrepreneurs. And again, if you are in the startup phase of your business, or you're looking to, strengthen your business by having some legal, fences in place, hit me up. Go to linktr.ee/NPL Consulting Firm, or hit me up in the DMs, and let's set up a 15-minute consultation. Okay. Have a great night. Bye. All right. Leave and stop.